آزادی بیان.
言论自由
Free speech.
So, should ACTA be adopted by the EU? Okay, you're going to be pleased to hear, in short, I think no, but not for the reasons that you might expect to hear. I think that I have a different perspective to the other speakers. I think ACTA should be rejected not because of potential harms to liberty, freedom, or future of the internet, but because it's a fundamentally poorly drafted piece of legislation which has not had proper scrutiny to ensure it can be fairly and equally applied in a bilateral manner. Let's take a couple of examples. Article 23 says each party shall provide for criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright or related rights piracy on a commercial scale. Well, generally I think that's okay. UK law already applies criminal penalties for commercial scale copyright infringement, section 107 of the CDPA if anybody wants to look it up, and in trademark infringement, section 92 of the Trademarks Act. But what are the words at least doing there? They're simply adding confusion and uncertainty which need not be there. Surely all co-drafters of ACTA can agree that criminal penalties are appropriate in cases of commercial infringement, but the civil penalties, possibly including punitive damages, are better suited to other forms of infringement. This will no doubt just lead to different states applying different standards, thus undermining the stated aim of ACTA to establish international standards for intellectual property rights enforcement. Another example of such plurality of standards is the famous Article 14.2, the TSA iPod provision. A party may exclude from the application of this section small quantities of goods of a non-commercial nature contained in a traveller's personal luggage. Why may? Why not will? Again, this demonstrates the problem of negotiating an enforcement treaty as a multilateral trade agreement. What's wrong with ACTA is not that it's substantively bad, it's because it's procedurally appalling and therefore is fundamentally flawed as a result. The usual IP drafting bodies like WIPO, WTO, UNCITRAL were locked out. Also locked out were anyone not subjectively in favour of strong IP enforcement. The developing countries from Brazil, Russia, India and China. Other developing economies were also locked out, as well as civil society groups. It's this lack of input that really, to me, makes ACTA useless. But that doesn't mean that ACTA-type provisions are all as harmful as we think. So my next question is an ACTA-type provision as harmful as we think it is? So here I begin by remembering that I'm speaking to a self-selected audience, and remember my point above about objectivity being largely illusory when dealing with matters of high emotive value. Repeatedly we've been told ACTA is harmful to free expression or will lead to monitoring of our internet activities or will lead to us being cut off or for websites to be blocked. that horse is already out. Bolt the stable door as much as you want, but it's already gone. Justice Arnold's looked after that. I, as objectively as I can, don't agree with these clearly subjective views. In their brief to the European Parliament, Article 19 state they're concerned that despite a single reference to protection of free expression in the preamble to the agreement, in the text there is limited references, and they suggest Articles 6 and 27. But note there is a threat to free expression due to a lack of guidance. But ACTA is an IP enforcement provision, not a fundamental rights provision. Let's look at TRIPS. Actually, no references whatsoever are made to freedom of expression in TRIPS. What about the Enforcement Directive? One reference, Recital 2, for those of you who are interested, and nothing in the articles. This is because these, and no doubt ACTA or whatever becomes next, must be read within the larger corpus of the law, and the people who draft it know this. Our rights are protected elsewhere, at EU level by Article 11, speech, Article 7, privacy, and Article 8, data protection of the Charter of Fundamental Rights. You cannot read an enforcement treaty separately from other provisions, in particular treaty or charter provisions. In effect, a well-drafted ACTA, not the one we have now, would, in my view, potentially be no more invasive or restrictive than the framework of laws that we currently have in place. So this is the IP Enforcement Directive, Section 97A of the Copyright Designs and Patents Act, and the Digital Economy Act, which is still there on the statute book. Don't forget it. It hasn't gone away.